All right, good morning, good morning, good morning. This is Thursday, April 27th, and we are running we're 2 minutes behind today, so I'm going to be a very quick intro. First, caveats. This is a public discussion. Anything you say can and will be used against you in a court of law. Also, it may be posted publicly. I want to just get right to our intro. David and Sonia are not only good friends, but they are probably the foremost experts in new construction in the province. There are people who specialize in areas of law. It's always good to go to them. Sonia and David have made a name for themselves, both for their customer service and for, of course, their knowledge of the law in this particular area. And to that end, they have agreed to generously spend their time with us and tell us about new construction, the clauses that are contained in a new construction agreement, and more importantly, the adjustments and the costs, which are of concern to all of our clients when they purchase one of these products. I am sorry about the entry and the passcode issues today. I think we're going to have less people here just because people were probably turned off and they couldn't get in. But we will be posting this, of course, and then we will have the uptick that we always do when that happens. So thank you very much, David, Sonia. Over to you. I'm going to go on mute and turn off my video unless you need me. I'm listening avidly.
Thank you, Mark, and thanks everyone for joining today. I hope some more come in as the passcode thing gets resolved. I'm sharing my screen. I hope everyone can see well. If there's any issues throughout, let me know. And I'm going to get right into it. As you know, Sonia and I are both here. We're a passionate real estate law firm, and we have an amazing team. I'll do most of the talking today, but Sonia will correct me slash just like at home because we're married and we're also business partners. Anyway, let's get right into pre-construction. Last week, for those of you who were here, we talked about assignments. What are you assigning? Actually, it's the agreement of purchase and sale. And that's a large document, sometimes 50 pages or so. And it comes with also a larger disclosure package, right? And you as a realtor, it's not your job to review it, but I'd like you to know a lot of things about it, at least some basic things about it, so that you're well aware. And of course, I'm sure if you're going to do, or if you have done pre-construction, you yourself are probably thinking of buying or selling. So it's just good stuff to know. So right away, you want to get the agreement to a lawyer to review it, because under the Condominium Act, any condo that is purchased, there's an automatic, whether it says it in the agreement or not, 10-day cooling off period or rescission period. So during that 10 days, you want to get the agreement to a lawyer, because it takes the lawyer more than a minute to review such a thing, right? It takes 1 or 2 days. And then the lawyer will help cap certain things and ask for certain changes, amendments. And then the builder has to review those among with, a few hundred other ones at the same time from the other units in the building, respond, and it can be a back and forth, and then finally possibly prepare amendments that need to be signed. So it's a process and it takes days to do. So it is somewhat urgent, please, to get right away when someone signs an agreement of purchase and sale, one of your clients, get it to a lawyer within a day. Okay, it takes about 10 days to do the whole thing. Rushing it is not great. On that note, we're talking about condos here and condo townhouses. If it's a house, a new construction house, there is no cooling off period because it's not governed by the Condominium Act. So there's a little bit of a risk there. So what builders do in those times are they typically will give you, and you may have seen this already, an unsigned agreement of purchase and sale for a house. And they say, get this to your lawyer, get it reviewed, and let's get this done urgently, because the minute you sign, it's a firm deal. You cannot get out of the deal, okay? That's how it is with houses. There are other, and that's like somewhat of a red flag, but you got to buy new construction houses, and this is the way it's done. So you want to make sure you have a good lawyer on your side. So I just want you to know there's no automatic right of a 10-day cooling off period for new construction houses. Okay. Finally, before we get into my our super duper rough numbers spreadsheet, which we're going to show with you and take you through, amendments. When you are, as a realtor, tasked with getting amendments for your clients, it's not just getting the amendment from the builder, it's getting it signed by your client, and then, and most importantly, getting it signed by the builder as well. That document, that amendment is useless unless both have signed it. We have had many arguments, and if any, I know Mark's here in the back, he doesn't have to pipe in, but if you don't have a signed amendment, a builder can just reject it, even though they drafted it. There's great arguments to be made that, hey, you drafted it, it was your intention, are you crazy? And we've had these fights, but we don't want to have fights and we don't want to argue. Get all amendments signed. Without an assigned amendment, and it says so in the agreement of purchase and sale, anything that is unsigned or not in writing does not count. Okay, I hope that makes total sense. If there's any comments or questions, feel free to make them as I speak. Sonia is monitoring that for me, and she might pipe in and ask those questions. I'm going to take you right into my super duper spreadsheet here. I hope you guys can see it. If you can't, I can increase the size. Why am I doing this? Because I want to show you what a lawyer should be looking at when they get a new agreement of purchase and sale. And it starts really at the information gathering stage. So for instance, I want to know if the client is married or not. Do you know why? Because during the 10-day cooling off period, I have so many clients say to me, let's say John Smith, or actually David Feld, so me, I'm the client. Oh, Sonia's the client. So Sonia Kalia says, I'm married, yet she's the only one on the agreement of purchase and sale. I see that all the time. So I say, hey, would you like to put your spouse on title? And 99% of the time, they're like, oh yeah, sure. I'm like, okay, great. If we do that during the 10-day cooling off period, there's no cost to do that. If you wait till after the 10-day cooling off period, there is a cost to do it, anywhere between $250, $350, all the way up to an assignment fee, because in some cases, builders won't even allow you to add a spouse. Usually they do, or a brother or sister or blood relative. Usually they do. But you don't want to play the game where your client wants to simply add a brother or sister or mother or father or spouse and have to pay up to $2,500, $5,000 for an assignment. So in the information gathering phase, even you as an agent, find out who should be going on title and put that in. Because during the 10-day cooling off period, all changes are free, but after that, they're not. Okay, another thing is find out if it's an investment right away, because that will affect the HST rebate, which we'll talk about. That'll immediately tack on $24,000 if the person, your client, is thinking of investing. Investing means that they're thinking of not living there, period. If they're not living there, it's an investment. That means either they're going to do an assignment or they're going to rent it out. Either way, that's an investment. An additional $24,000 for the HST rebate will be put on, and we'll talk about that. Okay, I don't want to get too much in it, but you could also find out if they want to put it in the name of a corporation. Sometimes they shouldn't put it in their name, but in the name of a corporation to help limit their liability. If they're doing various other things, they might want to do that. So these are different things that can be discussed. Getting down further into the 10-day cooling off period. Everyone asks this, when does the 10-day cooling off period actually start? Okay, it starts on receipt of three things: the agreement of purchase and sale, the disclosure documents, and the condo guide. Typically, all three will come together, but we have many cases where we just have the agreement and we start the review, and luckily they haven't sent the disclosure yet. So we literally can get our review done, go back and forth, and that clock hasn't even started. So we're quiet on that, right? But we do need the disclosure, mind you, to figure out numbers. So there's a catch-22 there. So, but we start everything and then we get that disclosure. But if anyone ever asks you, you need all three. And that is day one. Even if you get it at 6 p.m. on a Tuesday, that is day one. And days are days. Saturdays are days. Sundays are days. It's not business days. It's just 10 days from the date of closing. One thing we do with our clients is we actually say how many days are left and we say what day it is. We want to be very clear, because why? Because we want the client to say yes or no on that date. And it's very important to understand this. If you say nothing at all, the deal is automatically firm on the 10th day. Automatically, you must complete the transaction. You have to take a step, an active step, to get out of a transaction. So you have to say, no, I do not wish to proceed. Just by saying that, automatically, that's fine. The builder will give you your money back. We've never had a problem with a builder giving clients money back when they say no. So just make sure that and again, the lawyer should do this for you. But again, if you're buying or selling, make sure you have a definite yes or no. Typically, it's better to know more than like a few days before the 10-day cooling off period is over. Another big thing that pops up in new construction is the whole parking locker thing, okay? You see a marketing material, you get a free locker, or you see marketing material comes with parking. Marketing material, every single piece of marketing material that you see for new construction is just for fun. Think of it that way. It is not binding on the builder in any way, shape, or form. I still to this day get tons of emails and phone calls from realtors and clients, but surprisingly, even realtors saying, hey, do they get that free locker, or do they get the free this or that based on the thing? Not necessarily. We have to ask for that. Okay, we have to ask for that. So if there's anything not in writing, again, bring us back to, if it's not in writing, it doesn't count. So a lot of times we'll see something where it says you don't get parking, but you do get entered into the lottery for one parking spot, and the client thinks that means they get a parking spot, and parking is very important to them because they need to park their car. Well, I would say to them in that case, there is no guarantee of parking. Hopefully you'll get parking. maybe you'll get parking, but I personally will not guarantee that you will get parking. I would change this to a 0 in front of them during the call to say, I'm putting 0 here because although you hope to get a parking, there's no guarantee. So these are very important things. Parking and locker, you'd be surprised how many times people think that they get one, but they don't. So we make it crystal clear that the advertisements mean nothing and what it says in the agreements mean everything. So if there's anything changes we need, we get a signed amendment. This happens all the time, guys. Sonia, as I move down, any questions or anything of note? Not looking good.
Does the cooling off period apply for homes that include a POTL for the roads?
Yes, in most cases, if there's the way you can think of it is if there's some monthly fee that's going to be paid, that's because there's some sharedness going on. So that alone needs a condo corp, and therefore, yes, you can say that in those cases the Condominium Act applies, and therefore the 10-day cooling off period applies. A very good question. Okay.
And David, what about when we write to them and they asking for caps and amendments, and it's the 10th day and they haven't replied?
Okay, very good question. That's why I beg of you as a good realtor to get that agreement to the lawyer within the day 1. So by day 3, we're asking questions. So by day 7, we're getting answers, and the client can have a nice, casual, easy ease into the firmness of the agreement. If we're doing it late or if they're late. So what we do in every case is we say, here's our questions, and we actually boilerplate do this. We say we're asking for an extension until you reply. Hint, hint, we're asking for an extension until you reply. Because in a court, I think it would look pretty bad on the builder if they didn't reply and now it went firm. Now, having said that, that works a lot of times. So we'll get those delayed, we'll get an extension in writing from the builder until they reply. If on the day of closing, they still haven't replied, we write again saying we have not heard from you. It is very important that our client hear back from you, and we just put it on the record because we just assume that they will reply. Now, in most cases, the builder will then reply because it's an urgent. We write urgent and urgent, urgent. They reply to that one because they do want to close the deal. They should be acting in their client's best interest to close the freaking deal, especially now. Deals aren't closing, like people aren't lining up to buy these things. In the olden days, they're like, whatever, another dude's going to buy it 5 minutes from now. Who cares? So they are answering, we are pushing, and it's pathetic. I hate it. And I think Mark wants to say something on this topic. Go ahead.
Yeah, what I do regularly, I do something very similar to what David does. When I draft these letters, I say, I am the lawyer for X. We are in our 10-day conditional period. Be advised that we are only prepared to proceed in the event that you agree to the following things. And by doing that, what you do is you are withdrawing the permission reflectively at the beginning until such time as they respond and we say we agree. And so you're reversing the onus of the 10 days in the way you write your letter. Now, the builders have in previous times told me that that's legally invalid, and I've told them to pound sand. It's perfectly valid. It hasn't been tested in the court, but trust me, I'm right.
I could argue that one. That would be fun for another day. But the deal, if you say that, then you're basically saying I'm out. So the builder could read that as I'm out. You're saying I'm out. So
that's true. That's true. That is the downfall. That is the problem. You still have to monitor every single. You still have to monitor every single file and make sure it gets through the 10-day to completion.
Exactly. So that's great. Yeah. So the point is us lawyers have to come up with creative ways to like slap the freaking builder around to say, like, can you answer? Like, this is for your client and we're trying to all help each other here, right? And a good lawyer knows what to ask and what not to ask either, because when you're asking too many things, you're kind of muddying the waters and it just causes too many delays. Okay, good stuff. I don't want to talk much about Perennial today, but I do want to say they do give you right away when you get the paperwork, the agreement to purchase and sale, a first tentative occupancy date. In this case, it's January 6, 2025. That's just a placeholder. It's a moving target. This date will change for sure. There will be delays for sure. I don't think I've ever not seen that happen. During COVID, we saw all kinds of delays. We saw unavoidable delays, which really allows the builder to just delay for like ever. Now, for investors, delays are okay. Like hopefully the value of your property is going up while you've already put out money. So it's not the end of the world for many investors. They don't mind delays, actually. Some invite delays, okay? Because the value is going up and you're not spending more money during that time. For people who are going to be using the property as an end user, they're going to live there as their primary place of residence. Well, they're looking forward to moving into their new home and they're very pissed off about delays. So there's that give and take for delays, but there's going to be delays. I don't want to get too much into Taryn, but I just want to say there is an outside, many people don't know this, there's an outside occupancy date in every agreement. And here it says April 28th, 2031. So if in the year 2031, it's like so many years from now, and April, and let's say by then you realize it's still not built, then 30 days before that, so May, right? April, sorry, you have 30 days from that time to terminate. So you would say, hey, I no longer wish to proceed. And then all of a sudden, you would be able to get your money back. Yay. Now, how angry would you be to just get back your deposits in 2031, right? You just lost the time value of all that money. So in truth be told, most people would be angry, but would not walk away at that point. If the building is still continuing, they would stay on angry, but they would close and make a few $100,000 angry, but it would be okay. And then they'd pay a lot of capital gains tax and be angry, and that would be okay too. Okay, so I hope you get my little jokes there. Leasing during occupancy. Okay, so everyone's like, I would say 90 to 95% of all people buying in new construction are not living there. They seem to be investors, almost always. Coming through my office is almost always investors, okay? So the thing they want to know is, can I lease this out during occupancy? Because as I said earlier, if you don't lease it out during occupancy, you won't get back that $24,000 HST rebate. So it's very important. It's a very important question. Now, agreements of purchase and sale are like on a spectrum, so to speak. And some say, yes, you can lease. Some say, no, you can't. And some say, and most say, something in the middle. Cannot list, advertise, or offer for lease. So can't list it on MLS without consent. And the builder won't consent in 98% of cases to you advertising this. So you have to find your special ways. And you realtors know ways that I don't even know to market and advertise these, which is great. So you got to do it nice and clean because you're not really allowed to otherwise. And if you do, okay, because we've seen, obviously we do thousands of these a year. So we've seen many realtors do it. When you do it, you do get a major slap on the wrist. One, we get a letter and the letter says, you can't do that. You've breached the agreement. We could right now keep your deposits of $120,000 and relist and sue you for the difference. And then the client's very mad at you, the realtor. So do not list these things on MLS without written permission. It's serious. Now, luckily, the builder in that case goes on to say, however, if you remove the MLS listing right today and give us, and here's the bad one, give us a fee of $5,000 or something, and we're removing our caps. You know your development charges that were capped at 14,000. Oh, we're going to remove that. Oh, so what are the development charges going to be? Oh, we don't know. Like that's how bad it can get. It could be 20,000.
And worse, sometimes they remove your right to assign.
Oh, and then they could
So if
remove
you have a
your
right to assign.
And your right to tarry on compensation. Oh, we've had major delays. We'll let you back in, but we've removed your right to tarry on compensation by you signing here. So it gets ugly. It gets ugly. Okay, I just want to say. So you want a nice, and this is what your lawyer helps you to do. You want a nice leasing condition that just allows you to lease. They'll never out and out allow it, or some will, but it's okay because the truth is, when you ask for consent to lease, I would say 98 to 100% of builders will allow you to lease it because they'd be crazy not to. You were the investors who helped that builder build that building. Now they're not going to let you rent it out. They knew that was the purpose, so they always allow it. Thank God. Okay. The minute you rent it out, I want you guys to remember three things, and please memorize this. I wrote it here on the slide as well, but I want you to memorize this. This lease with your tenant has to be a minimum of a 1-year lease, cannot be less. Remember that. 2, it has to be with a person like a John Smith, not a corporation, not ABC 123 Incorporated. And 3rd, they have to be the first occupant to live there, not you. Oh, I lived there for 60 days and now the new guy moved in, the tenant with a 1-year lease. No, that causes problems and they are solvable, but they're not accurate, and you want to be accurate. So the first person has to be a John Smith for 1 year. Please remember that, because then it's a slam dunk for us to get you the rebate, $24,000. I'll check that is written to you 3 to 4, now it's 4 months after the final closing, okay, of $24,000 to pay you back for the extra $24,000 you paid on closing. I hope this makes sense to everybody. It's super clear, but it's amazing how many times people get this wrong. Okay.
And John Smith needs to be using the property as their primary place of residence, not as his secondary office, not as his Toronto office location, not like it has to be a primary residence for the tenant.
Exactly. Okay. Very important, because that is the point of the rebate, that someone is using it as their primary place of residence. Okay. And we can get into what that means in another day. But you primarily live there for most of the year. Let's just say that. What about assignments? I mean, honestly, guys, assignments today are huge. They're coming in by the truckload. I just did a TikTok video. Guys, follow me on TikTok at David the Feld, because I'm going more real estate there. So follow me there on Instagram at David the Feld. And make comments, ask questions, always good. Assigning before closing, that's big. Can I assign this whole agreement to someone else before closing? And we talked about this last week. And almost every agreement says you cannot assign without consent. So you got to get consent from the builder for sure. And they often give a one-time non-transferable right to assign, and you're not allowed to list on MLS. Again, if you do that, automatically they can pull the deal. Now, I haven't seen them pull the deal, but the letters are ugly, and the pointing of fingers towards realtors gets ugly. So you don't want to be involved in that, okay? I've seen so many realtors do it. The flip side is a lot of realtors list it for 3 days, and then they get the letter saying don't do it, but they sell it in those 3 days. Just telling you, such exposure for 3 days. I don't recommend you ever do that, but I'm just telling you the truth of what happens. I'm saying don't do it. I'm saying don't do it. I'm looking right in the eye and saying don't do it, okay? You can lose your license. All right. Request to assign must be made no less than 60 days. So like occupancy is coming, you're getting all these notices, you're getting finally occupancy is coming. You have to do it no less than 60 days, because if you're doing it too close to occupancy date, then they're very busy. They're going to say no. And builders, by the way, can say no if you make things difficult for them. So use a good realtor, you guys, and a good lawyer to get these assignments clean and done. They can say no, okay? They can. It's hard. It gets ugly if they say no for everybody. Another thing is it says vendor must have sold at least 100% of the model types. Let's say you're like in 503, that means 603, 703, 403, 303. They're all the same. The units look the same. The builder has to have sold all of those for you to sell. If they haven't sold the one above you, they're not going to let you sell yours, because you're now competing with the builder. So they just say no. So you hope they've sold all theirs. Now, usually by the time occupancy has rolled around, they have sold everything. So in essence, it's just stopping you from assigning early on, which truthfully you wouldn't do anyway, because the value of the property has not gone up enough during the sales time, during the first year, for you to sell by assignment. And that's why it's prohibitive. You don't sell by assignment, okay? Typically, there's a fee for assigning, ranging from $0 in the olden days, that's long gone, to about 11. The lowest I see these days is about $1,100, which is paying the vendor's legal fees, all the way up to $10,000 we see plus HST, all the way up to $25,000 to $30,000 we see in new build houses assignments. Reason why is builders don't really love you assigning houses so much as they love you signing condos. So it's prohibitive. So they sometimes put a $25,000 fee on assigning a house to make you not do it. People still do it, and sometimes they do well. Okay, so houses are more to be lived in and rented out rather than to be assigned, I would say. Okay. Any questions, Sonia, before I continue to move on here?
We did have a question about the penalties for posting on MLS if the builder says no, which I've replied to, that you're in default. And typically the builder will give you some time to correct that default. And as part of their conditions for allowing you to correct that default and reinstate the contract, they can also take away certain incentives that were provided to you at the time that you signed.
Exactly. And that's ugly, because those incentives that your lawyer hopefully negotiated for you have a high value. So when you assign, you want to assign the caps. Do you know that this is something we talk about a lot. I don't know if other firms do it. We talk a lot about transferability. Can you transfer those caps to the new buyer? Now, it's not always the case that you can, and we caught on to this early. So we actually get the builder to commit to transferability in many cases, so that when you assign the contract, we transfer a lot of those amendments over that say that they're not transferable. And let me give you an example of what that means. Imagine we get to final closing and the capped development charges of $14,000 are not transferable to the purchaser. And now the statement of adjustments shows $25,000. There's going to be a big fight. They're going to say, we didn't agree to this. We were told it's 14,000. You gave us an amendment showing 14,000, right? So what the hell? Now it could be a fight back and forth, and the answer isn't clear. There might be a negotiation. Someone will lose. Both will lose a little bit to get to the end result. You don't want that. We don't want any of that crap. That's garbage. That's bad. We don't want it. So we resolve this early on in our stuff. Okay, moving on to the HST rebate. It's a very important thing that everybody, including realtors and some lawyers, are getting wrong all the time. So I just want to say there's HST and then there's the HST rebate. They're two separate things, okay? So first of all, just memorize these two things if you can. One, HST is included in the purchase price. So that's all I want you to know. When you buy a condo for $600,000, HST is included in the purchase price. Remember that, because people always ask that, period. Okay, next, there's an HST rebate. That's something different. That's also included in the purchase price if you'll live there as your primary place of residence. And that's $24,000. So if you're paying $600,000 for a property, you will have to pay $24,000 more if you won't live there. Okay, if you will live there, it's included. So you just pay $600,000 for the property. Get it? So HST is included and the HST rebate is included in the $600,000 if you'll live there as your primary place of residence. So simple, yet everyone gets that wrong. But let's flip it. Now we get that, so let's flip it. If you won't live there, so that means you're doing an assignment or you're investing. Just if you won't live there, period, it is an investment, period, and you will have to pay an additional $24,000 to close for sure, period. Okay. Now the good news is, and it's really easy good news, at final closing right away, same day, because you have a deed now, we can apply for the HST rental housing rebate and get you the $24,000 for sure if you follow my 3 simple rules. Again, you remember them, and I wish you guys could all turn on your mics and say it with me, but 1-year lease with a person who's living there as their primary place of residence. Okay, got it? Okay, beautiful. Does everyone understand that HST rebate thing? And do you have any questions about that? Because I get so many calls every day from realtors and even lawyers about HST rebates, but in actuality, it's not difficult. It's quite simple. Any questions? Oh, one last important HST rebate thing. Every time you do an assignment, no matter what, this is now always, the new guy, the assignee, the purchaser, the final purchaser, has to pay an additional $24,000, whether they're living there as their primary place of residence or not. So a good lawyer and agent would advise the purchaser, hey, you're gonna have to come up with another $24,000 for sure. So many people don't know that, it's crazy. But again, the good news is if you're living there as your primary place of residence or renting it out, there is a rebate for you and you will get the full $24,000 back after the closing. So you just got to come up with it, put it out there, and then the CRA will give it back to you as long as you follow simple rules. Okay, that's what I wanted to say about HST.
I just want to mention the number of people that I hear from who have purchased new build as investors and were not aware that they could apply for the HST rebate is astounding. People have paid $24,000 on closing and not applied for the rebate for years and years and years, and they eventually lose their right because of the limitation.
2 years.
Period, a 2-year limitation period, and they're like, oh, well, nobody ever told me I could apply for a rebate from the government.
That hurts. And
So
I honestly
it does
believe
hurt. It's really important to tell, like, I don't know if the lawyers are going to tell your clients, so I'm asking you guys, you know, like, tell your clients, tell your investor clients, if they say to you, I paid an extra 24K, blah, blah, blah. And you say, hey, listen, you know, you can apply to get that back, right? You just need a tenant there on a 1-year lease.
I agree. And I actually almost call this negligence on behalf of the lawyer for not advising the client of an easy $24,000 they can get back. And I've seen it. How do I know? Because they call us. They're like, hey, I closed with, and is there any way, I just found out through your TikTok that there's an HST rebate of $24,000. Can I apply? And they literally, we look at their paperwork. We're like, yep, we apply right away and get them the money. And it could be that there's 1 week left before the limitation period is up. And I'm like, dude, ridiculous. Okay. So please. All right. Any questions about it? Usually HST rebates, there's lots of questions. Anything there, or can I move on?
So we also have, it says it's important to use an accountant. He would file for the rebate. So an accountant can file for your rebate. A person can file for their rebate. Or we as lawyers also offer that option to our clients as part of their closing and like an after closing service. Would you like us to apply for the rebate for you? The cost is roughly $650 and people are getting back $24,000. So usually we do it part and parcel of our closing at our office. Just because we have all the documents available to us and we can make that rebate application quite quickly. An accountant, I have talked to a myriad of accountants. Some of them know a lot and some of them know nothing. And so I would suggest that you go through your lawyer for this type of thing, as long as they're comfortable with that, and they've been doing them, regularly.
The HST rebate is a standalone rebate that you can do like with the real estate lawyer. The reason why I agree with Sonia about the accountant thing is I love accountants, and I'm sure Mark Morris will agree with me. I love them, but they speak a little bit different language. And if they haven't done a ton of these rebates, they can mess up the rebate. Now, the problem is when you mess up an HST rebate, it goes into HST rebate hell. And you're literally waiting a year and is back and forth, and they make conclusions on their own that can open up a major can of worms that you don't want. So just use someone who does HST rebates all the time. There's a way to do it, and also there's a name, like they even someone who's done it a lot. The CRA knows that these guys do applications correctly. They kind of just check mark them quickly. Okay.
And Dina wrote here, clarification, if the property's an investment, are they still eligible for the rebate? I thought it had to be primary residence. Sanchita, thank you for answering. So investors are eligible. There's two kinds of eligibility, okay? So one is the eligibility with the builder up front. So that means you don't pay it. It's going to be your primary place of residence. Builder agrees with that, and you don't pay it at all, and you don't apply for the rebate, right? The second one is you're not eligible with the builder. So they're going to charge it to you up front, but you are eligible then to apply directly to the CRA if you have a 1-year lease with a tenant who is the first occupant using it as their primary place of residence.
Okay.
So there's still that opportunity to apply. You just have to pay it up front, and then, but you remain eligible just directly with the CRA versus via the builder and via their statement of adjustments.
I'll even say this, you can get the HST rebate in almost every single case back, okay? Except if it's a secondary home. So it's next to impossible to get it back if it's not a primary place of residence. So if someone's got a home and then they buy a second condo, but they're not renting it out and they're not living there as their primary place of residence, they can't get back the $24,000. And I even try to coach them in the legalist way possible to get it back in a certain way that they have a tenant with someone, but a lot of my very wealthy clients don't do that. So they are okay to lose the 24,000. Okay. I want to talk, but otherwise you can get it back. So I want to say about 4 or 5 things that are important to remember about all new build agreements that most people don't know. So you'll become much smarter just by knowing these things. So first of all, parking and locker, they can be redesignated by the vendor in their sole discretion. So imagine your client is elderly and they really are happy with this spot they're getting right near the elevator. That could be changed and there's nothing they can do. And that needs to be told to the client upfront, because they can get very upset because like, I only entered into this whole building because of that parking spot. Well, you shouldn't have. And we need to let you know that in advance. Okay. And there's never a case where they allow this. Okay. I've had clients, also very wealthy clients, buying like a $15 million penthouse condo, and they want these 2 amazing spots that are like, the creme de la creme of spots. You would think it would go with the unit. No, they got the ugly spots right beside it, and they were so angry. Anyway, so also if you're going to be directing title into a corporation, the names under the corporation have to be matched. Like if there's one person on title and you're directing to a corporation, then there can only be one person who owns that corporation. It has to match. Okay. You will have to provide a mortgage pre-approval at some point. Okay. Another thing is, and I wish I could open up mics and do a skill testing question here. When you get to interim occupancy, you have to pay occupancy fees, and occupancy fees are made up of 3 things. Do you guys know what the 3 things are? The first thing is condo fees or maintenance fees, which is from the budget, which is increasing even from the time of the budget due to inflation. Those numbers are increasing. By the time you get to closing, it's not even matching. Okay. And then property taxes, estimated, because they can't possibly know the property taxes at the time of interim occupancy fees. The building hasn't even been assessed yet by the tax department. So there are adjustments that are made later on. And then interest on the Bank of Canada rate for a 1-year conventional mortgage. Okay, whatever that is. The rate right now is very high. Does anyone know what it is? 6.3, I'm guessing. I don't remember, but it's very high. So the occupancy
6.03 as of yesterday.
Yeah, so occupancy fees have gone up. Even that's gone up. Everything's gone up, but even occupancy fees have gone up. Okay. Then I don't want to get into too much more here. I really wanted to make sure you understood all that. We can skip a lot of this. Okay, good. Let's get into the estimated costs now. And I can take some questions after that. So let's use a real example here. This is a purchase price of 700,000. Deposits are typically 15 to 20%, with most typically 20%, and they're staggered with dates. And when you've made all your deposits, typically you'll make your last deposit on occupancy. So occupancy is when you get the keys. Occupancy is when you can either rent it out or live there. And usually on that day or just a day before that, you'll meet your lawyer, pay the last deposit check, in this case 35,000, 5% typically, and you'll pay your occupancy fees, which I just said are made up of three things. And again, I wish I could get you guys to yell it all out, but condo fees, taxes, and interest on the unpaid balance. So you would bring 12 post-dated checks. People always say 12 post-dated checks. What does that mean? Does that mean my interim occupancy is going to be 12 months? Not necessarily. Typically, interim occupancy is 3 to 6 months, typically, but it can go longer than a year. It can go up to 2 years before it gets ugly, and we don't see it go 2 years that often, okay? So, but you're paying this 4108 every month, or the builder will cash one of these checks every month, and then let's say 4 months in, it's the final closing, they'll take the remainder of the checks and they put them in the shredder, okay? So that's how that works. And they prorate that month. So let's say they cashed your 4108 check for that month, but it's 15 days or so. So you'll get back half of that, 22,000 something dollars. Okay. I hope that makes sense. Now I want to talk about deposits. So we talked about new construction. You're always making a deposit to the builder's lawyer in trust. And that's a safe place for it to be, because as you know, sometimes builders go under and you want your money back at least. And that's great. In other countries, you could lose your life savings when a builder goes under. So at least we have those protections. I want you to know something, and Mark, you can chime in if you disagree on any of this, but when it comes to new build houses, a lot of times, and we check this diligently, the checks are to be made out to the builder, not the lawyer, not their lawyer in trust. When I see that, I cringe, because I don't know that builder a lot of times, and I don't know if they're going to take that money and go. And it's happened infrequently, but it's happened. Especially now, costs of buildings going up. Maybe it's a new builder. Maybe they, with the best of intentions, were going to build everything, but they ran out of money. What are they going to do? They can't give it back to you. They should have kept it in their trust account, but they're not lawyers. They're not bound by anything. So they spent it. So they're gone. So you lose the money. So what do? Our firm, we demand that those checks not be written to the builder. We demand that they be written to their lawyer in trust. The success rate of that demand is not 100%. So sometimes we get it. We're so happy. We think we're the cat's meow, if people still say that saying. But sometimes they say no. And then we tell the client, there is a risk here that the builder will not complete this transaction and that you will fight for years to get your money back, and you may never get your money back. If you're okay with that risk, please proceed. So be wary and understand that you can request big changes on agreements. They can say no, but you should request that change. We do. We get it for our clients. It's a much better situation. Okay. So that's what I wanted to say about deposits, okay? Then we talked about interim occupancy. Now we get to final closing, typically 3 to 6 months later. How much will they have to pay in closing costs? Well, the average these days is something like 5%, which is normal, okay? So normal is 5% on top of the purchase price. What makes up this 5%? Well, some of the bigger things are development charges. Now, in this case, the development charges were previously 8,000. We negotiated them down to 6,500 plus HST. Everything's always plus HST, by the way. All statement of adjustments, or most statement of adjustment items, are plus HST. We show them in our spreadsheets to the clients just so they can, have the money ready for closing. So if a good lawyer gets these capped. Now, why is it important to cap these? Well, development charges are like, well, here it says 8,000 plus HST. It could, if it's not capped, first of all, that's a red flag. It's an orange flag, we call it. If it's not capped, you must try to get it capped. And in most cases nowadays, builders are not stupid. They will cap them, or a good letter from a lawyer will get you your cap. However, there's this Section 37 agreement charges. Now, builders these days are capping some and not capping some. What are Section 37 charges? No one even knows what that is. Okay, so I'm hoping you still see my shared screen here. And you should hopefully see this PDF pop up in a few seconds. Here it comes. Last time I clicked on this, it showed up like instantly. But okay, I'll just tell you what Section 37 charges is. Okay, and if it pops up, it doesn't. So Section 37 charges, when the builder wants to change things, and they do, right? As you know, during your own, Sonia and I learned during our own renovations, we change things all the time. But imagine in a builder, you have to make a bunch of changes. So you apply to make the changes, and the government will say, okay, you can make these changes so long as you pay for these other things. And it just falls in the other tax compartment, like development charges, park levies, and Section 37 agreement charges. Those are the three charges that builders charge to help grow the city, to make it better. Okay, so they say, okay, we'll allow you to rise up to put like 5 more floors here, but you're going to pay extra amount, and then they divide these up to each buyer. So here in this case, 14,690 is our estimate for Section 37 agreement charges. So you really want a lawyer that knows about these things and tries to cap them. You can't always cap them, and in this particular case we couldn't. So we estimate, that's why it's in orange, 15,000 bucks. This could be higher or lower, and a good lawyer explains to the client this could be higher or lower, and you have to take that risk. So the only risk in this whole agreement is, what are these Section 37 agreement charges going to be? They could be higher or lower than this number. Okay, we tend to aim high so that people are happier, but we can't know, and we let the client know that. Okay, great.
I like to refer to this as like a community benefits sort of cost, right? This is the cost for adding community benefits as part of the building that they're building. And every municipality has their own bylaw about how much is to be charged for this. So whether your client is buying in Toronto, or if they're buying in Durham, or if they're buying in Peel, like we would tailor this estimate and this charge based on their municipality.
Exactly. Lastly, there's things like hooking up the telephones, hooking up the water stuff, like water leak detection system. Even wiring money now they charge for, and then they and electronic registration fees. So they charge all their little fees here too, bringing us to 37,000. We try to delete all of these. That's our system, and every builder's lawyer knows us very well, so they know, like, we have a system where we provide them actually a chart that they fill in. And then of course you got to pay your legal fees to your lawyer, okay, and land transfer tax. Now if it was in Toronto, this would be double, right? But if this one's not in Toronto, so it's just $10,000. Okay, subject to first-time home buyer rebates. So if they're first-time home, this is another fact I want you to memorize. Okay, it's just a legal thing. If you're a first-time home buyer, you've never owned any property anywhere in the world, then you get a first-time home buyer rebate. That's awesome. So, but let's say you're a first-time home buyer and you're buying this condo and you're not going to live there because you're going to rent it out. You don't get the first-time home buyer rebate, and you never will. You lost your right to the first-time home buyer rebate. You've now gone on title to a property, so you can never get the rebate. And that's how it goes. However, a little trick, and I hope I'm not talking too fast. A little trick, assignments. If you assign the first property, but don't ever close on it, then you never did own a property. So the next property you buy is really the first property you ever bought. And so you're a first-time home buyer if you're going to live there. And that's the trick. So you could be like, yeah, I've bought 2 properties, sold 2 properties, moving into my very first property now, and I'm going to take advantage of my first-time home buyer rebate. That's cool. You could do that. Okay. All right, guys. I think I've covered everything I wanted to cover today. Do you have any questions for me at all? Are there any questions in there? You can even come on, and talk if you like. While we're waiting for that, follow me, guys, at TikTok and Instagram, same thing, at David the Feld. I'll start doing much more real estate content. Everyone's been asking for that, so I'll do that, and ask your questions there so I can do videos to answer your questions, and it'll show your name as well, which is good for you.
Awesome. Guys, maybe we can just have people unmute themselves. We have a bit of a smaller group than normal because of my screw up earlier, but we still have a sizable group. We have about 40 people here. So maybe given that we have a bit more of an intimate setting, we can just do this verbally. Anyone have a question, just unmute yourself and feel free to ask. By the way, I'm just going to answer Lita. Lita, just so you know, what Sonia said is correct. People often get first-time home buyer land transfer tax exemption and the first-time home buyer RRSP use confused. The first-time home buyer RRSP use resurrects itself after 4 years, but the first-time home buyers is a one-time deal in your life.
Yeah, so that's funny. Like, just like HST and HST rebates get mixed up by people all the time. Same with first-time home buyer for land transfer tax purposes and first-time home buyer for RRSP purposes. So just to repeat what Mark said, the RRSP one repeats. So people sometimes call and say, hey, don't I get my first time home buyer rebate now? It's been 5 years. No, you don't. You only get that once in your life. The first property you buy that you live in as your primary place of residence, you get your land transfer tax rebate. You never get it again. It doesn't reset like the RRSP does. Very good question. Anything else?
Hi, everybody. This is Taha. I have a question. So what is on the statement of adjustments by a builder, what entails additional consideration, which is not subject to HST, but they do the calculation at the top where it's not included in the net price, but it's but the calculation is done at the top, like that's where the builder kind of lists it.
Yeah, Sonia, I knew.
Yeah, so the things, those are subject to HST, and that's why they put them at the top, because they want to, there's certain adjustments that you must pay land transfer tax on. So your purchase price is not just what you agreed to pay. You are paying land transfer tax on the purchase price minus the HST, plus the HST rebate, plus certain builder adjustments like carry-on, development charges. Those are all land transfer taxable. Okay, so that's why they put it on the top, and they include it with HST as additional consideration, and they'll add it to the purchase price. And then from there, they will remove the HST in full, including the HST that would have applied on those adjustments, so that you're not paying tax on tax, because you don't want to pay land transfer tax on HST. So then from there, they remove the HST, add in the rebate, and then that's what they give you as the net builder price. Back in the day, that used to be our responsibility to calculate as buyers, lawyers, the consideration that was subject to LTT. Now, a lot of the builders adjustments will do this for you, but still put a disclaimer in there saying it's your responsibility to confirm that you're paying land transfer tax on all the sort of necessary items of consideration. But that's why they put it at the top there. And those things are, it's not things like common expenses and any of those prorated. It's not those items. The items subject to land transfer tax are the things that truly get added to the purchase price by the builder. Okay, it's not your cost of operating the unit or your cost.
The one-time fees, right?
Okay, thank you. That makes sense.
Yeah, so you're actually paying a little less land transfer tax than you would on the full purchase price because it's a little less, so that's good. Okay, any other questions?
A quick question about freehold.
Yeah, go for it. Freehold of houses?
Yeah, are you starting to see builders adding a schedule for rescission period instead of offering agreements for preview?
For sure. Some builder agreements, first page says you have 15 days from the date of signing this. Like they impose a 15-day cooling off period. It's identical. It's smart. That's what they should do. So every smart house builder should just put a 10-day written cooling off period in there, and that's good. And some don't. And then when they don't, those are the ones you see with no signatures on them. And then there's no cooling off period. There's still some degree of rush because, well, not these days, but there used to be lineups. So like we'd have to get in our order sheet, get the thing done, negotiate with the builder and close the deal before the next person would buy. Right this minute, it's not like that. So, but there's a back and forth that happens before signatures get put to paper. That's silly. You would think the builder would want signatures on a paper, so they should put it imposed, written 10-day cooling or 15-day cooling off or 5-day cooling off period in there. Mark, you want to say something about that?
No, David, you're handling this ably.
David, for delayed occupancy, can a buyer get compensation from the builder? Yes.
After the firm, okay, you go ahead, Sonia.
Yes, if the occupancy date has been declared as firm. You only get compensation once the builder declares the firm occupancy date, which comes after 3 to 4 delays prior to that. So once it's firm, then you start to be entitled to delayed closing compensation if they then change that date.
Sonia, can they still send an unavoidable delay notice after the firm occupancy date?
Unavoidable delay is the one exception where they don't have to pay delayed closing compensation, because that is considered like
unavoidable
that they had no control over, right? So whether it's COVID like a worldwide pandemic, strike, these kinds of things that the builder cannot control. In
So
which
they
case-
can still issue that notice after the firm occupancy closing, and then the purchaser is not entitled to any compensation at that point.
The
I missed that
unavoidable
question.
delay- Well, they have to give you notice.
Yeah.
They have to give you notice for 10 days prior to changing the firm occupancy.
Oh,
date. And
understood.
if they don't, then you get that 10 days. Like you get that delayed closing compensation up until your notice, because they have to give you
Mhm.
notice.
Got it.
Okay, great.
Non-resident speculation tax is still payable on assignment by foreign buyers. Assuming your assignment was firmed up prior to January, when a foreign buyer could buy in Canada.
I'm literally getting this
Yes.
question every single day. So can my foreign buyer buy in Canada? And I was gonna call you, Mark, yesterday and say, have you figured it out? Because I literally all of a sudden, all the foreign buyers want to buy like crazy now. They're like, I can't buy it. I want to buy 10. I want to buy 20 now because I can't buy it. People love what they can't have. And
Tatiana, the answer is yes. So assume your foreign buyer is entitled to buy because they signed prior to January of this year. So assuming they are in fact entitled to buy, then yes, they will be subject to the NRST unless there is some exception that they fall under, like a spouse. They have a non-foreign spouse, Canadian spouse, whatever it may be.
on the topic of foreign buyer, the foreign buyer ban, you can't, like a lot of people could basically enter into an agreement and hope the ban goes away in a year or two, and then they just close on the deal and no one was the wiser. And I'm sure they're doing that, but builders are working in some clauses and some paragraphs into their agreements that say, if you've entered into this illegal or in any way, shape or form, we are not taking any responsibility. We will keep your deposit and sue you for damages. So it's on you, the buyer, to know that you can do this. We're not going to check, so to speak. So we're seeing a little bit of that to protect the builder from foreign buyers who may not be able to close. I mean, I think you and I, Mark, think this ban will go away before any of these deals close, and probably some people will skate through, but I don't think it's going to stay. In fact, I don't know if you guys know, it takes up to 2 years to pass legislation. So when they thought of this foreign buyer ban, maybe it was a good idea when they thought of it, but by the time they implemented it, it was a very bad timing, and we could use the money right now, and we could use people buying. It's weird. Like the law moves too slow for the market, I guess, always. And yeah, that's all I have to say about
Just
that.
being cognizant of time, if husband and wife are buying together for their primary place of residence and the wife owns an income property, will the husband count as a first-time home buyer and receive the benefit? No. If you are married to a homeowner, you are not a first-time home buyer, even if you've never owned a home. If we have an assignment done, it gets tenanted during interim occupancy and the new assignee does not close later on, what are the consequences to if we have an assignment done, it gets tenanted and the new assignee. So I assume the new assignee is the one who has the tenant. I'm not sure I understand the question, but on an assignment, if an assignee doesn't close, depending on the terms of consent, typically the builder, in an assignment, the original purchaser, the assignor, always remains liable for the contract, okay? But there's some circumstances, and that's not, so that means the original purchaser has to close. That's my simple answer to you, okay? So my simple answer to you is if an assignee doesn't close, the original purchaser has to close. Having said that, I have seen situations where the builder has decided that rather than allowing the original purchaser to close, they are going to nullify the agreement, not give that opportunity to the original purchaser, although they have the right to require the original purchaser to close. They are not going to exercise that right. Instead, they are going to nullify the agreement and relist, depending on the market. So really, it's at the builder's option what they want to do is my convoluted answer to that. But my simple answer is assignee doesn't close, assignor is responsible. That doesn't mean assignor has a right, though, to get their unit back necessarily. The builder can decide, no, I don't care. I don't want you closing. This is done, this whole thing. So that's my sort of answer to that one. What if American citizens?
Last one, guys, and then we're going to wrap up because we're hitting 11.
Okay, do they still have to pay any other foreign that I'm not thinking of? What, pre-conduct 2016? Is there there's no grandfathering clause for NRST? Is there? Mark, David?
Sorry?
Is there a grandfathering clause for NRST?
I actually believe that there is, yes.
is? That David signed, right?
The way the legislation is actually worded, if you actually read it, is that it's only applies to units that have been purchased after X. So there actually is a grandfathering clause there.
Same as with the foreign buyer.
Yeah,
grant.
exactly.
Also
Exactly.
for the NRST.
Yeah.
Yeah, okay, Sanchita, I think you should just look up the ministry website for the grandfathering clause. There's a great one pager that the ministry has done on the NRST with a bunch of FAQs and stuff. I can't remember off the top of my head. I feel like there is a grandfathering clause, but you should check that up.
Perfect, thank you.
Yeah, so it has a grandfathering clause.
Yeah,
Yes, it does.
okay.
Yeah. All right, guys. So look, there is a reason that David and Sonia are the ones that are presenting this. There is a reason that people use David and Sonia every time they have a new construction. P.S. You can use me too, but anyways. There is a reason that David and Sonia are known as the pre-construction experts, guys. And you can see their systems are built around processing these deals accurately with a fine-tuned knowledge of the law. It is strongly suggested you use them. And others who understand the new build space for your deals. We're privileged to have them here. They're perennial favorites. They come back and they talk about these issues because this is what they focus on. This is what they concentrate on. This is their bread and butter. And it shows. So guys, we are incredibly grateful to your time, to your energies, to giving time to the group. We will post this online as we always do. And I thank you sincerely for everything that you give to our group and specifically for today.
Thank you so much. And, great seeing everybody. And we're always here to help. And I'll say, Mark, we're very good friends out of here too. We call each other every day about legal matters. We're always trying to stay on top of our game. And it's amazing how the camaraderie we have and how we try and help solve all of our clients' problems together. It's really, really.
In fairness, it's because you have cooler drones than me. So I'm just looking to borrow. All right, guys.
Anytime.
Have a good one.
Okay, bye, guys.
An excellent seminar. Thank you.
Thank you so much.
Bye.